thank you for being here to celebrate the 230th anniversary of the ending of the convention in Philadelphia that gave us our Constitution. That 230th anniversary was yesterday, and now we're started on 231. Today's session is going to start with a good long bit of history. An ounce of history is often worth a pound of logic, as has been said more than once. And it's peculiarly true, I think, in the case of understanding the Constitution as it stands today. We'll talk a bit about circumstances before the Constitutional Convention. Then we'll talk about the opposition to the adoption of the Constitution, quick review of the structure of the document and its amendments, and then briefly I'll talk about a few Supreme Court cases that involve the enforcement of the Constitution. So let's get on with the history. Pre-1774, was there really an America? Well, you can argue it in many different ways. At the time, many would have said there is a British America, a French America, a Spanish America, and a peculiar Native America. Well, from our point of view, it's really British America that counts. Those 13 colonies had been formed largely as profit-making enterprises, but also, in some instances, in order to gain particular freedom for certain religious practices. They were very different in nature and in size. They began to understand in the years following what we call the French and Indian Wars that there were some common problems that they shared. So they began to think about ways of getting together. And the first real steps were these committees of correspondence that were formed in the various colonies, and they would correspond with each other. They would talk about common problems, about what to do about that nasty parliament off in the UK. The first of these, we think, met in Massachusetts in 1764. Now, this was not the only thing that happened. There was, in fact, one broad meeting of representatives from 9 colonies, the Stamp Act Congress, called in order to oppose the stamp tax imposed by the Parliament. And they decided, well, we'll draft a document, we'll send petitions to the King, the House of Lords, the House of Commons, and so on. And they declared that the people of these colonies cannot be represented in the House of Commons, and that only local institutions could rightly impose taxes. Why was it so hard for these colonies to get together? Well, it's fairly obvious. First of all, think of transportation. There were no automobiles, bicycles, railroads, canals, steamships, or hotels. You did have some roads. It took a stagecoach 3 days to get from Philadelphia to New York City. Amtrak does it in an hour and 7 minutes. There were flat-bottom boats on rivers, and there were a few inns or taverns that were springing up here and there. Anyone ever been to Essex, Connecticut? Oh, sometime if you're in that area, stop in at one of the very few pre-United States taverns that's still operating, the Griswold. It's a lovely place. There were problems with communication. No telephone, no telegraph, certainly none of these, all of which I'm sure are already turned off this morning. There was a postal service. In some places you got mail once a week. More often you got it once a month, or, well, whenever the person who had the local commission filled up that mail bag. There were newspapers slowly coming into being. There were 37 at the time of the Declaration of Independence. 1774, the first Continental Congress meets and adopts a document called the Continental Association. The Articles of the Continental Association imposed trade boycotts with English merchants until there was a repeal of various oppressive laws, and a call for action by each colony's government to enforce those bans. There was a recognition of those committees of correspondence that we talked about. And finally, there was an assumption that a multi-colony Congress would continue to exist. It did, and in 1776, as we know, declared independence. What did they think about America at that point? Well, look at the phrasing, the familiar phrasing of the Declaration of Independence. It spoke of our charters, our laws, the forms of our governments. We, therefore, the representatives of the United, with a small u, States, with a big S, of America, in General Congress assembled, declare that these colonies ought to be free and independent states, plural. Something, however, had to be done to get a more unified war effort going. And so the Articles of Confederation were drafted. These articles created a union of states, each of which, as I note here, retains its sovereignty, freedom, and independence. Provides for a Congress, single house, to meet every November. And here's a curious thing. Each state has one vote, but sends a different number of representatives. We're beginning to creep towards something recognizing the differences in the states. And it does put some limit on the power of individual states. They cannot negotiate treaties, declare war, engage in military action without permission of the Congress, except in the case of what they called Indian raids. There's no true executive under the Articles of Confederation. There is a president of the Congress who has some powers to do things when the Congress is not in session. And that's all. Term, 1 year. They do establish some courts. One to deal with piracy, the other to settle boundary disputes between the states. Wasn't working very well. The Virginia State Legislature in 1786 issues this invitation for the various colonies to come together and talk over really bad problems that they were having, including near bankruptcy of the federal government and the various measures that different states use to get the better of other states. Well, the meeting of commissioners takes place in Annapolis in September 1786. They don't reach agreement on many things other than that we need to do something, and we think the Articles of Confederation have got to go. Something better has to replace them. They send this message to the Continental Congress, and the Congress decides it will issue a convention call. And so we are launched on something. Why all of this concern? Well, part of it has to do with money. Between 1774 and 1800, according to the work of these two economists, personal income went down from $85 million to $65 million. You'd notice that. Much worse in the South, by the way, than in the Middle Atlantic and Northeastern states. Moreover, there are worries about defense. It's quite clear that the local militias are falling into pretty poor condition. Not everywhere, but in a number of the colonies. And that some of the colonies would not be able, in case of war, to meet the obligations, if you would, that they had accepted under the Articles of Confederation. There are other worries as well, but let's skip over those for the moment and get to the convention itself. The convention began in May of 1787 in what we now call Independence Hall in Philadelphia. This is the reason we have that very impressive Constitutional Museum in Philadelphia. 12 states, no longer colonies, 12 states out of the 13 send representatives. Rhode Island, as we'll see again a time or two, was a rather persnickety state. And they were not sure about all these goings-on in Philadelphia. There were numerous proposals for the reform of government. The principal ones being the so-called New Jersey plan and the Virginia plan, small state plan, big state plan, but there were, in fact, a multitude of plans. What were the divisive issues? Well, the small state, large state division, representation by population, by economy. How do we share out responsibilities and powers? What do we do about the slave trade? Interestingly enough, this is about the time that in England we see developing true anti-slavery sentiment. It was slow in coming, but it was beginning to spread to the United States through occasional contact with the former mother country. What should be the powers of the Congress? Should it really have extensive power? Or should most things still be dealt with at the state level? And in particular, when there would be a difference between national government and state government, what should be the last word? The so-called Supremacy Clause issue. The outcome, well, as we all know, there was a big change. The article started out, "We, the undersigned delegates of the states." The Constitution, as we all know, begins, "We, the people of the United States." We are now national citizens. Article 2 of the Constitution provides for a very strong executive, not a one-year, not a chairman, but an independent executive. Not seated in the Congress. This individual is going to be commander-in-chief. This individual is going to appoint all the responsible officers of government, is going to make treaties, and is going to have a veto power that will at least slow down those strange people on Capitol Hill. The Congress, this time, is not one house, but two. This is, in large measure, a resolution of the large state, small state problem. The small states have two senators, just like the big states. But in the House of Representatives, it matters what your population is. The bigger your population, the more representatives you have. This is a powerful body. Article 1, Section 8 is in many ways the core of our national government. The Congress has the power to tax, to provide for the common defense and general welfare. That's pretty broad language, isn't it? The common defense, the general welfare. The Congress will have power to borrow money, regulate commerce with foreign nations and among the several states. It will have the power to coin money, establish a uniform rule of naturalization, establish post offices and post roads. I'm not sure they had the interstate system in mind, but provide for patents and copyrights, constitute courts, declare war, raise and support armies, but notice, for no more than 2 years. The standing army was a great worry for the people who are drafting this Constitution. We had had a standing army in the years of the French and Indian Wars and thereafter, a standing British army that was immensely unpopular. The soldiers were quartered in individual homes. Eat you out of house and home? You remember that phrase? Standing armies. But the militias were falling apart. What do you do about that? Well, you provide for organizing, arming, and disciplining the militia. All right, the states get to appoint officers for these militias that are not standing armies. But the authority for training is to be exercised according to a discipline prescribed by Congress. Turns out it's a discipline that was written out by Henry Knox, for whom Knoxville is named. This former bookseller, who had become an artilleryman for the purposes of the Revolutionary War, wrote what he called an order for a well-regulated militia, a phrase we'll see again. The Congress will have power to govern what will become the District of Columbia. It's not called that in the Constitution. And then we make all laws which shall be necessary and proper for carrying into execution all these other powers. the Necessary and Proper Clause. This is a powerful Congress. The powers of the states are limited in a number of other ways as well. Article 1, Section 10, no state shall enter into any treaty, coin money, impose a law impairing the obligation of contracts. Congress can do that, but the states cannot. Grant a title of nobility, lay any duties on imports or exports. Commerce within the United States is not to be discriminated against state by state. Keep troops or ships of war in time of peace, or enter into any agreement or compact with another state or with a foreign power. Oh, that one got challenged, we seem to recognize. And there is a qualification. You could do that with the consent of 3/4 of the states. But without that consent, you may not enter into a compact as a state with another state. The Supremacy Clause, Article 6. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties shall be the supreme law of the land. Anything in the Constitution or laws of any state notwithstanding. We're no longer a confederation, we're a nation. Some other illustrations, the full faith and credit clause, that's largely carried over from the Articles. Section 2, the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. That one doesn't crop up often, but when it does, it can be terribly, terribly important. As in the Obergefell decision of the Supreme Court a couple years ago. Finally, there's the guarantee clause. The national government shall guarantee to every state a republican form of government. Now, this doesn't mean the states lose all their powers. New states may be admitted into the Union, but you can't, in the Congress, do that so that you carve up an existing state without its consent. If the Constitution is to be amended, the states, acting state by state, not population-wide, decide about that amendment. You can't take away the equal state representation in the Senate without a state's consent. Finally, we get the proposals about ratification. 9 states will be enough. The Articles of Confederation had said, well, you have to have unanimity, but let's not worry about that. 39 of the delegates sign the proposed Constitution on the 17th of September, 1787. It's transmitted to the Congress under the Articles on September 20th. That Congress votes on September 28th to transmit the document to the 13 states. And now begins the war of words. I've picked some of these because we hear them still. That's part of the American way, isn't it? All right, you lose today. Let's see if we can't come back somehow. Some way. First, and The overarching argument of many opponents is that the national government is just too darn big. It's too far away from those of us in our individual communities. You heard anybody complain about the big federal government lately? Well, you have quite a history for that. There's a belief that the immense size of the country is such that the executive folk won't be able actually to run things. Golly, I mean, you're running from Maine to the Florida border and as far west as the Mississippi River. Golly, that's huge. Can you actually expect postmasters out in that far west? Those people in Nashboro? Oh well, that's one argument. Here's one that I am not sure we hear anymore, but I have to include this because it relates so directly to our state. Depriving the states of the power to raise armies. The writer of the letter, called Cato, says is a bad idea, since if the state of New York and that of North Carolina had armies under their control, they would never have lost Vermont and Franklin. Now, Franklin, I'm sure, is that short-lived state of Franklin up in East Tennessee that had tried to organize itself because it was simply not possible with the Appalachian Mountains in the way to get any sort of sensible representation over in the North Carolina legislature. As we know, didn't make it, but eventually North Carolina itself recognized, yes, we can't really govern those feisty, disagreeable folk west of the Appalachians, and so they would let us go. Just interesting, I think, to see this concern about the state of Franklin in the anti-federalist literature. Having centralized power over naturalization is unwise, and I want to quote this one. For though most of the states may be willing for certain reasons to receive foreigners as citizens, yet reasons of equal weight may induce other states, differently circumstanced, to keep their blood pure. Charlottesville. Another one. Given the concentration of power in the national government, the, quote, wealthy and aristocratic are likely to take it over, and this group will act like the screw in mechanics, always gaining, holding fast what it gains, never loosing. In other words, if you let the wealthy loose, they'll buy the Congress. They'll buy the office of president. Familiar? And it's a concern that is very much shared by my colleagues who are true constitutionalists. I'm a labor lawyer. Constitution? I do real law. Well, at any rate, my constitutional law brethren, by and large, are concerned about the decision in the Citizens United case a few years ago, which essentially says those with billions can spend all they want in any variety of ways to seek to get the kind of president and Congress they want. The proposed structure is too complicated, but doesn't have enough checks and balances. That's an argument that surfaces constantly today, that this government we deal with is simply so complicated, we don't know how to deal with it. Finally, there's an anti-adoption argument that was shared by many supporters of adoption of the Constitution. Most state constitutions at this point included bills of rights, spelling out individual freedoms of various sorts that the states could not take away. There was no Bill of Rights in the original Constitution. Now, what happens? Well, things start out pretty well. Remember, it's October, really, when the states get this document. Two months later, Delaware ratifies the Constitution in its convention by a vote of 30-0. 5 days later, Pennsylvania ratifies 46-23, a 2-1 margin. New Jersey on the 18th of December, 38-0. Georgia, day after New Year's, 1788, 26-0. January 9th, Connecticut, 128-40. February, Massachusetts, 187-168. Woo! Things are getting tight. Now, how did it get through in Massachusetts when two of the most prominent citizens of the state were so opposed, Paul Revere and Sam Adams? Well, what happens is that Paul Revere switches sides. He says, look, if this convention will do something no other convention has yet done and suggest to the initial Congress that we need some amendments to provide a Bill of Rights, then I'll go along with this. And he took his friends, and there were many of them, with him. And so Massachusetts ratifies. Now, Rhode Island. Rhode Island hadn't gone to the convention. And when they got the document, they said, we don't like this idea of a convention. We think everybody ought to vote. And so they just posted copies of the Constitution hither and yon on church doors and whatever, and said, folks, you vote on this. And the voters, well, did they understand or not? All right, April, Maryland ratifies 63-11. Things look like they're going along again. South Carolina 149-73. June 21st, New Hampshire 57-47. And this gives us 9 states. But it's a close call. Those independent mountain folk in New Hampshire. June, Virginia ratifies 89 to 79. Near thing, Patrick Henry was a major opponent of adoption. Had Thomas Jefferson been in the country, there's a very good chance the Constitution would not have been ratified by Virginia. Jefferson was very worried about the powers of the president. Now, there's a great irony here, obviously, in that he was the individual who went far beyond anything that's spelled out in Article 2 and made the Louisiana Purchase. But he was worried, and you can tell in the correspondence that had he been in Virginia, there's a good likelihood he would have argued against adoption, and given his prominence, that might well have done the trick, despite the fact that no one in Virginia was nearly so highly regarded as one other figure, George Washington, who had been the president of the Constitutional Convention. So it passes in Virginia. New York ratifies by 3 votes. The state that had us at that point, North Carolina, calls a convention. And we can identify with this. They say, we'll suggest some amendments and go home and think about this. 9 states having ratified, the Congress says the Constitution is in effect. They issue calls for elections. The Electoral College, which we still have, selects George Washington president, John Adams vice president. The Congress is supposed to meet the first Monday in March. They can't get a quorum together because of those problems of transportation till April, but then they are there and we get started. It doesn't take long for that first Congress to decide, it was a close call. Let's respond to these people who ask for a Bill of Rights. And so they proposed 12 amendments. 10 of them are ratified very rapidly, 1 much later. Our good North Carolina folk get back together and say, well, everybody else has done it, we might as well. Rhode Island says, maybe that general vote thing wasn't such a good idea. They call a convention and ratify by 2 votes. Scrappy people, those Rhode Islanders. Now, one additional little quirk here. You remember that quotation from Cato about New York losing its claim to Vermont? Well, both New York and New Hampshire claimed Vermont, and the Vermonters said, we don't belong to either one of you. And so they said, we're going to call a convention. And they did. And they ratified, and the Congress recognized it, and they became the 14th state. After that, admission to the Union was a matter for the Congress to determine. Just a quick reminder of how the Constitution is put together. I'm sure you all know this. Article 1 is the Congress. Article 2 is the President. Article 3 is the judiciary. Article 4, that full faith and credit clause, national citizenship, Congress to control the admission of new states, the guarantee clause. Article 5, amendment. Article 6, this nation will continue to recognize debts incurred during the Revolutionary War, provides for an oath of office, and has that Supremacy Clause. Now, about those amendments. As I said, 12 were sent out. 10 became our Bill of Rights. The 27th Amendment, adopted in 1992, was the first one, it was the second one of those 12. And it simply provides that the salaries of the members of Congress are determined by the immediate prior Congress. You can't vote your own salary. You vote the salary for the next Congress. For some reason, that just sort of sat on the desks of the legislative leaders hither and yon around the country forever. Finally, Michigan became the state that led to the adoption of that particular amendment. That's just a little quirk of things. We all know the Bill of Rights. Amendment 1, freedom of press, speech, religion, petition. Article 2, the well-regulated militia and the bearing of arms. A very controversial provision, the interpretation of which has led to 5-4 decisions and 6-3 decisions any number of times. Third, we don't like standing armies. That's also a part of the message of the second. Fourth, no unreasonable searches and seizures. That one still causes a fair amount of controversy. 5, if you're going to be charged with a serious crime, we're going to take the procedure for doing that very seriously. We're also going to say you don't have to testify against yourself. And interestingly enough, in this largely criminal law-oriented provision, we get the provision saying no property is to be taken without, quote, due process of law, unquote. What due process means? Criminal cases, right to speedy trial and trial by jury. 7th Amendment, right to trial by jury in civil cases. 8th, no excessive bail, nor, and here's one of those other phrases that is difficult to reach agreement about, no cruel and unusual punishment. Then 9 and 10, sometimes referred to by my constitutional law brethren as the truism amendment. Enumeration of rights in the Constitution doesn't disparage other rights retained by the people without spelling out in any way what those rights are. And 10, powers not delegated to the national government nor prohibited to the states are retained. Any number of groups try to make more of the 10th Amendment than the language provides, but thus far that has not succeeded. The rest of the amendments, 5 of them, interestingly enough, try to clean up the presidential election and succession process. There was that terrible time when Jefferson and Burr got the same number of votes in the Electoral College. Oops. So we decide, all right, electors vote for president and vice president separately instead of together. Thank goodness for that one. We changed the dates for the beginning of the Congress in terms of the president. No president to serve more than 2 terms. Those unrepresented folk in the District of Columbia do get to vote for president. And finally, what do we do if there's no vice president? And this one got passed just in the nick of time. For only the second time in our history, a vice president resigned. Spiro Agnew. That hadn't happened since a slightly awkward situation in the early 1800s, which created no real problem. So Gerald Ford becomes vice president. Then the vice presidency is vacant again. and Nelson Rockefeller becomes vice president. These are the 1970s. This amendment was adopted in 1967. Sometimes we're smarter than we deserve. 5 more amendments deal with other election issues. 2 are particularly important. The 19th, providing that women must be allowed to vote. Significant for us because Tennessee was the 36th state to ratify that amendment by 1 vote, and that was the state that was needed for adoption. And then the right to vote for those who at the time were eligible for the draft. We don't have a draft at the moment, but the argument was if you're old enough to die for us, you're old enough to vote for us. Pretty good argument. Then there are the post-Civil War amendments, 3 of them. Wonderful book and movie about getting the 13th adopted. That was the toughest in many ways. Then the 14th, which today is in many ways the most significant. All persons born or naturalized in the United States are citizens both of the nation and of their state of residence. Their state of residence can't make a contrary decision. They are entitled to the privileges and immunities of citizens. Not spelled out in detail, but very important. And nothing can be done to deprive people of those privileges, immunities, or property without due process of law. Now, each of these 3 contains a provision empowering the Congress to enforce that amendment. This is an addition to the powers we reviewed before in Article 1, Section 8. And the Congress has done so in each instance. Then we get 2 dealing with prohibition. One saying, oh, let's get rid of that nasty whiskey. And the other one saying, well, it's been a hard day. Let's have a drink. 2 more of some significance. One reinstated the doctrine of sovereign immunity, which means the ability of the state to say, you can't sue us for damages. And the other, empowering the Congress to tax incomes. We're all familiar with that one. I want to spend just a few minutes now talking about how we enforce the Constitution. As you know from television news and newspapers and magazines, declarations of unconstitutionality ordinarily are made only at the Supreme Court level after the most serious deliberation. This is what we call negative enforcement of the Constitution. You negate something that the Congress or a state or a federal officer has done. The first instance of this occurred in Marbury versus Madison in 1803, not that long after the adoption of the Constitution. Mr. Marbury had been appointed a Justice of the Peace for the District of Columbia. He was a Federalist. The Federalists lost that election. That was held that year. And somehow the Secretary of State, who at that point had the privilege of delivering such documents, had not gotten around to giving Mr. Marbury his commission. So Mr. Marbury sues in the Supreme Court to get his commission. The Supreme Court says, yes, you were duly appointed. Yes, you're correct. It is not proper for the Secretary of State to continue to hold that commission and not give it to you. But you lose. Why do you lose? You lose because the statute that said the Supreme Court of the United States shall have original jurisdiction to issue writs of mandamus, that particular kind of legal remedy that orders a government officer to act, that statute was unconstitutional because the Constitution spells out that we are a court of appellate jurisdiction. We hear appeals, or we hear a couple of other kinds of cases as a court of first instance. Cases that involve other nations. Cases that involve boundary disputes between states. But since the Constitution gave us only that amount of original jurisdiction, you can't give us more. Our powers are limited by what the Constitution gave us. But it's not just acts of Congress. I don't think many in this room will remember this, but a few of us will. 1952, President Harry Truman seized the steel mills. There was a huge labor dispute going on in the steel mills, and Truman didn't think the mechanisms provided by the Wagner Act and Taft-Hartley Act for resolution of that dispute was going to keep the steel mills in production. And if you recall, we had a small argument with Korea. History does repeat itself, doesn't it? At the time. And so he was very concerned about this, understandably. Supreme Court takes the case and says, no, this executive order is improper. It goes beyond what is provided for in Article 2, unless you get specific additional powers from the Congress under Article 1. And then third, the Supreme Court uses its power to strike down state laws on occasion. The first instance being this one, McCulloch against Maryland. A state law taxed the federally chartered Bank of the United States in a way that imperiled its ability to function. And the Supreme Court said, no, the state cannot do that. There's a famous phrase in the opinion, the power to tax is the power to destroy. Negative enforcement. Some people argue that there are times when it's appropriate for the courts to get into what we think of as a kind of semi-affirmative enforcement. Prominent example for us is the decision in Brown versus the Board of Education of Topeka, Kansas, the decision that struck down racial segregation in the schools. Many of us remember the years following that decision. There were billboards urging the impeachment of Earl Warren. there was Governor George Wallace standing at the front door of the schoolhouse saying, "You shall not pass." The federal district courts, of necessity, given the resistance, took up case after case after case, dealing with school boards and saying, "Come back with another plan because this one won't do. Come back with another plan," and sometimes finally saying, "All right, the representatives of the minority group students, you come up with a plan. And just maybe I'll impose that." And it happened, and it happened, and it happened. And it is true that in many places, the schools were desegregated successfully. But if you go to Alabama or Mississippi or rural Georgia today, and you go to those public schools, it's a different story. As if they were prepping for me, the editors of the New York Times did me a favor. And if you look at the Sunday magazine for September the 10th, you will see the facts and figures. About school segregation in the United States. If you're in California or Massachusetts, it's one thing. If you're in Alabama or Mississippi, or arguably in parts of rural West Tennessee, it's a different thing. I don't want to say the courts can never engage in, quote, affirmative, unquote, enforcement successfully. But they're not equipped. What do the courts have? They have clerks and a handful of marshals. By and large, the courts rely on us to carry out the decisions. Well, enforcing the Constitution is not just for the courts. The President and the Congress have roles also. The Congress obviously has to decide before taking up legislation, all right, yes, this is something we can do under Article 1. Presidents are supposed to enforce laws. What do you do if you decide a law is unconstitutional and you're supposed to enforce it? Well, this is the position that most presidents have taken, and we saw it very recently in the case of the United States against Windsor. What we will do is enforce the statute, but we won't defend it when appropriate parties challenge it in court. If the Congress wants to do that, they can set up a mechanism for doing so, and ordinarily the courts will allow the Congress then to participate. But the Attorney General will take the position that we are not defending this statute. Finally, there is a way of dealing with serious executive and federal officer misdeeds, and that's impeachment. Article 1 says that the House of Representatives shall impeach, Senate shall try. It's happened twice in our history with presidents. Nothing has happened. few minutes ago, I mentioned that remedy of mandamus that Mr. Marbury sought. Why not use that? Well, because there are doctrines that say this cannot be done when the official you are trying to make do something has discretion with regard to that issue. You get it occasionally, but very, very rarely. Then there is this political question doctrine. The courts will not deal with matters that essentially are entrusted by the Constitution to the political process. I have a long quotation up here. I won't bother you with it. But there are 6 steps, if you would, that the court said it would take in deciding whether an issue is a political question. So, how do we enforce the Constitution when the government doesn't do what it's supposed to do? I use this illustration simply because if I was asked once last year about this particular issue, I must have been asked at least 100 times. There's this wonderful nominee. Why can't he get confirmed? The president has the power to appoint the judges of the Supreme Court by and with the advice and consent of the Senate. The nomination was made in March. The Senate did not act for 9 months and 18 days. If this went to the courts, if the Attorney General of the United States went to the courts, there would be no writ of mandamus. Political question. Discretion. What do you do to enforce the Constitution? Yes, impeachment would have been possible, but remember, it's the House of Representatives that decides whether to issue a bill of impeachment against, in this instance, the majority leader of the Senate. Both are under control of the same political party. You have no remedy in the courts. There is no real remedy available in the Congress. Want to enforce the Constitution? Shake hands with the enforcer on your right. Message of Constitution Day 2017. Your most fundamental right is voting. When you have a chance, do it. Thank you so much. Questions, comments, arguments? I've been running off at the mouth a long time here. You can't take an university professor and expect less than 50 minutes. Well, let me say it has been a pleasure to be here, and I much enjoyed the opportunity to think a bit about the Constitution. As I say, I'm a labor lawyer, and I don't get to delve into things at this high level very, very often. I'm more likely to be asked about how to apply Section 13A1 of the Wage and Hour Law and decide who gets overtime and who doesn't. Dealing with things at this level is a real pleasure. Thanks so much again. Oh, a question, wonderful.
I was going to ask you, whenever you look at the Constitution, from your perspective, what do you think is the most inspired piece of
It is difficult to say. I believe myself that if anything is truly significant about a particular section, it is that necessary and proper language in Article 1, because that was an admission, it seems to me, by the drafters of the Constitution that we don't quite know what we're launching this nation on, but we're going to do it anyhow. And risk takers like that don't come along every day. Whatever is necessary and proper. You successors of us, you find something that's necessary and proper, you do it. And we've been doing it for 230 years. So if there's one little phrase in there that I particularly fix on, that I think is it. Anything else? Well, thanks again.